He was an absolute sacrificial lamb.
Police officer Jason Van Dyke's attorney on the trial, the verdict, and the prospects for an appeal.
Phil, as you heard earlier, convicted police officer Jason Van Dyke has been moved to Rock Island County Jail after spending the weekend in custody at the Cook County Jail. This after a jury found Van Dyke guilty of second-degree murder and 16 counts of aggravated battery in the shooting death of Laquan McDonald. Van Dyke's attorney blasted that verdict and called his client, quote, absolute sacrificial lamb. Both sides now await sentencing. And joining us tonight is Daniel Herbert, who has represented Jason Van Dyke since charges were first filed in 2015. Prior to developing his own law practice, Herbert was himself a Chicago police officer for more than 9 years and a Cook County prosecutor for 4. He's also worked as the in-house lawyer for the Fraternal Order of Police in Chicago. Dan Herbert, thank you for being here.
Thank you.
First of all, to the news of the day, was there any specific safety threat that prompted the move to Rock Island County Jail?
From what I understand, there was not a specific threat. I think it was just a precaution. And Rock Island is designed to deal with high-profile clients such as Jason Van Dyke. So I think the sheriff made the right call in this case, and they're being very precautionary.
Have you spoken to your client in the last day or couple days since the verdict?
I have not spoken to him since the verdict, and we spoke for about an hour afterwards. I've spoken to his family, and I am going to actually go visit him tomorrow or the next day.
And so that hour discussion you had afterwards, what was that like?
It was tough. It was tough, and it was there was a certain sense of relief because, you know, we went into this facing a death sentence, and he realized that he was going to be able to see his family again. He was going to be able to see his kids graduate from high school, hold his grandkids, go to his children's wedding. So it was not the verdict that we wanted, but there really was a sense of relief, especially the way everything played out in this case.
Well, in essence, you know, you saw the family and protesters, they were pleased with the verdict, but was this sort of the best possible outcome for your side too?
You know, it really was, and I've thought about it the last couple of days. I've spoken to a lot of friends and colleagues, and, you know, my client never enjoyed the presumption of innocence going into this proceeding from pretrial all the way through post-trial. It started with the concealment of the videotape, and then there was convictions in the press by the mayor, by the state's attorney's office. There was a Department of Justice report that condemned my client. There was a task force accountability that condemned my client. The media condemned him, and then there was this subsequent criminal investigation of 3 police officers for a conspiracy, which essentially eliminated my ability to present a proper defense in the way that I wanted to.
And we should clarify for everybody, there's a big difference in the sentencing guidelines for second-degree murder versus first-degree murder. So what are the sentencing guidelines now? Yeah,
well, first-degree murder was 45 years minimum. So that would have been a death sentence. With second-degree and the aggravated battery counts that are currently on the table, the court is going to have to decide which one it's going to sentence on, because it cannot sentence on both. So for second-degree murder, it starts at probation. It's a probationable offense, or then it goes from 4 years to 20 years. And with the ag bat, the way that it's charged, it would be a minimum of 6 and a maximum of 30 at 50% time.
So are you prepared to say what you're going to ask for when you face the judge for sentencing?
Well, we're going to ask that the charges be dismissed and that the verdict be dismissed because the evidence did not support the verdict. That being said, we are prepared to enter a sentencing proceeding where we're going to show that my client absolutely deserves the minimum sentence in this case, just like any other defendant in Cook County that is a first-time offender.
You're going to file a motion to dismiss, so specifically what evidence did not fit the verdict? What are the specifics of your case to have this verdict tossed out?
There's several, but I think the first and most prominent is there is a law that we argued extensively throughout the trial, the police officer use of force statute, that we argued this after the charges were filed, and essentially what it does is it allows for a police officer to use deadly force not only to defend themselves or somebody else, but when effecting an arrest. And that law was ignored by the prosecutors in our pretrial motion, it was ignored by the judge, and it was ignored by the jury in this case, because the fact of the matter is that there is no evidence to dispute the fact that Jason Van Dyke had the right to use force under this statute, and that was ignored by everyone in this proceeding.
At the same time, the jury came back and said they felt good about their verdict and that the video was sort of the main evidence. So what, other than that statute that you say was not considered, what did the jury fail to see that you saw?
Well, normally I would be really upset with the actual jurors in this case, but given the backdrop of this case, it's hard for me to second guess the jurors, because this was a jury from Cook County. The problem that we stated in our numerous motions is that it's impossible for a jury in Cook County to come back with a not guilty verdict across the board for Jason Van Dyke, going back to their neighborhood and telling their neighbors that, yes, I was the one that voted not guilty for
So you
him.
really believe they felt pressure and that's what made their mind up?
There's not a doubt in my mind. During the voir dire, there was actually activists that were seated in the jury room with an individual juror sitting there, and some of the activists were calling for violence in the neighborhood should there not be a not guilty verdict. So there is not a question in my mind that there was pressure on these jurors.
Can you explain what you mean when you say that Van Dyke was a, quote, sacrificial lamb?
He was absolutely sacrificed by politicians, by his leaders in the police department, because it was expedient and best for their interests. This was never a first-degree murder case. The fact that it ended up as this case had been investigated for over a year. They had the only piece of evidence, the video, for that whole time period. So if they thought this was such a horrific crime, the charges would have been brought the next day. They weren't. They were only brought after this cover-up of the video happened and the media started reporting about it, and then the politicians recognized, wow, I can use this for my political favor, or I can use this to offset, some of the negative polls that I've been receiving, and that's what happened.
At the same time, every juror who saw that video, and most of the observers who saw that video, and then the animation that you produced that ostensibly showed it from Van Dyke's vantage point, said it still didn't match Van Dyke's story, that the video was overwhelming, that Van Dyke's life wasn't threatened.
I would agree. The video was overwhelming from an evidentiary standpoint. I know that now as I sit here. And that's not from the evidence that went into the trial. Every piece of evidence that we had in the state's case and in our case showed the problems with that video. In our animation, it disputed the narrative that has been prevalent throughout this case, and that is that that Laquan McDonald was walking away from Jason Van Dyke. That video showed, and it's indisputable, that Laquan McDonald was advancing on Jason Van Dyke.
The jurors still, they didn't agree with that, and they thought that Jason Van Dyke's explanation didn't match with that animation.
I agree. That's what their verdict is, and that's another basis for our appeal, is that listening to some of the jurors' comments, they commented on factors that is against the law, essentially, and we had jury instructions that we proposed that would have answered those questions that the jurors had. One juror mentioned how he believed that Jason Van Dyke should have used lesser alternatives prior to firing. Well, the law says he doesn't have to. A couple other jurors indicated that, well, the other police officers didn't fire, so Jason Van Dyke must have been unreasonable to fire. Well, the law, the Supreme Court says no.
There's no law that says, but to that point, there were 10 other officers on the scene. They didn't see fit to fire, so were they then, under your explanation, not doing their job if Jason Van Dyke was acting within the law?
I think that they let that situation get out of control. No. Do I think they should have used force? If they would have used force, they would have shot him in the back, and that certainly would not have been explainable. But the point that we made throughout the trial, and it's indisputed, is that the only person that was in anywhere close to the position that my client was in was the state's third witness, Joe Walsh, who said, I would have shot him had Jason Van Dyke not done that. So at that point, the first-degree murder should have been off the table. But it wasn't in this case, and we all recognize why.
Should also be mentioned, Walsh is facing charges in another trial in this case. Jason Van Dyke, again, we mentioned the jurors did not buy the specifics of his testimony. Was it, in hindsight, a mistake to have him up there?
No, it wasn't a mistake. Some jurors said that they didn't find my client credible. They thought he was rehearsed. Well, none of that was from any cross-examination or impeachment. They simply had a feeling or a gut reaction that they didn't believe my client. I can tell you that my client was one of the least rehearsed clients that I've ever had. He went up there and simply wanted to tell his story. And had we not put him on the stand, those same jurors would have been saying, well, he didn't testify because he's guilty and he didn't want to get up here.
Why does his version of the events not match up with the animation and not match up with the video that everyone's seen?
Because it's impossible. The video cannot show what Jason Van Dyke was witnessing. And one of the biggest points where part of these police officers that are charged with the cover-up is about the knife coming over the shoulder. Well, the prosecutors just missed the boat on that one. They assumed that it meant the knife over the shoulder. Everyone said it was the knife over the shoulder this way. So, and that's part of the cover-up allegations against these 3 police officers. So they should be exonerated on that point because the evidence is exactly that he went over his shoulder on that.
What can you tell us about how his wife and children are doing now?
They're trying their best. They're trying their best. In one sense, they're relieved that they know they're going to get their dad and their husband back at some point. But, you know, this guy's been destroyed. His family has been destroyed. Their lives have been destroyed. And, you know, Tiffany, his wife, is, I said Jason was the toughest man I've ever met. Tiffany is the toughest woman I've ever met. And their sole focus is, what can we do to keep our family together? And I am so proud of those 2 people, along with their support staff, their family.
You know, Jamie Calvin was the journalist that really started this whole ball rolling, getting that video out. And one of the things that he said was, the system failed Laquan McDonald, but it also failed Jason Van Dyke. Would you agree with that assessment, that in a way that he's sort of a victim of the system? Bad training, bad protocol, a cover-up mentality?
Yeah, there's no question. And, you know, I agree with Jamie Calvin on that. The system certainly failed Laquan McDonald. I mean, Laquan McDonald's life was nothing short of tragic. And all those factors led into his behavior that night. And it's shameful. It was tragic. But, yeah, Jason Van Dyke, the training in the police department, and I used to train there, so I wear the jacket on this somewhat. But the training and the policies that are in place were not good. And here we have a law. The Illinois legislators created a law that says you can use deadly force against fleeing felons in these situations, and that law is completely meaningless because the courts and the juries don't even consider it, but it's still on the books, so we better get rid of that law.
All right, Daniel Herbert, thank you so much for being here.
Thank you.